Welcome to Midas Touch Legal AF. If it's Saturday, it is Legal AF Live. If it's Sunday, it is Legal AF. But if it's any day of the week that you listen to Legal AF, you got us. Ben Meiselas, Michael Popok, delivering the key legal cases, key legal issues of the week in digestible ways that you can understand. Some have said this is Legal AF University, and people feel that they are getting that law school experience. We are not an accredited law school. I put that as a disclaimer.
We're unaccredited.
We're unaccredited. But Popok, I want to just say to you, I heard the new Legal AF podcast that's on Wednesday. It's on the same podcast channel. It's you with Karen Friedman Agnifilo. For those listening now, Karen Agnifilo was the number 2 at the district attorney's office in Manhattan. She was Cy Vance's number 2. So we're honored and humbled to have Karen Friedman Agnifilo on there. And Popok, I like the way you announced that podcast. When I heard it, I knew there was going to be great energy. You started off, you said, Popok here with Karen Friedman Agnifilo. Very inspiring, Popok.
42 episodes with you, my friend. A bit of it has rubbed off. And I realize now, not that I didn't always have tremendous respect for you and admiration for you, but you've got a hard job because I kind of played the Ben role with Karen, and we're still trying to find our way. We had a great show. I think people complimented the chemistry and what we were able to accomplish in 30 minutes in a drill down. But, you know, this is like a fighter jet. You know, I consider you for our show, the main Legal AF, the pilot. I'm the navigator, and you and I take turns being the gunner. Karen and I are going to find our way through this. One person wrote up and said, let her talk more, like as if I'm the interviewer and she's the guest, as opposed to 2 co-anchors that are having a conversation that hopefully is interesting. We'll get there. Give us more time. Ben and I are on episode 42. Karen and I are on episode 1. But it'll come. We'll figure out who's the navigator, who's the pilot, who's the gunner, and it'll be a really fun time. But you have a very hard job in making this show run smoothly.
And that show drops every Wednesday. And Popok, there are a lot of qualities I like about you. You're smart, you're intelligent. Some have even said silver fox Popok. But what I like about you, Popok, is that you are self-aware. The self-awareness right there is what adds to your brilliance. But that said, let's go into this week's legal issues. We've been following Ghislaine Maxwell's motion for new trial.
Good pronunciation.
Great pronunciation.
Said it perfect.
Great pronunciation.
It's really good.
But not a great situation going on in the Southern District of New York right now. And for those listening to Midas Touch Legal AF, you know about the jurors who spoke with the press. There are jurors who spoke with the press in the UK, in the United States. This motion for new trial, as we mentioned on the last podcast, is drilling down on one specific juror who checked on the juror questionnaire that they said no to the question, have you ever been a victim of sexual harassment, sexual assault? This individual was a victim of sexual harassment, sexual assault on the juror, and used that experience apparently to convince jurors to find guilty on the counts that Ghislaine Maxwell was ultimately found guilty of. There was multiple days of deliberation, and Ghislaine Maxwell's team filed this motion for new trial. I've predicted on prior Legal AF podcasts that this motion for new trial, I believe, is going to be granted. Popok, what do you think is going on here?
Yeah, I think it's exactly what you thought it was and what we talked about last podcast last week. Juror number 50 is the entire focus of the motion for new trial, and that's the juror who gave an interview to The Guardian in London, or actually the Daily Mail in London, and disclosed that not only did he tell the other jurors in the deliberation room that imperfect memory of sexual abuse does not mean it didn't happen, and he referenced personal experience, basically becoming a pseudo-expert in the room, bringing into the room really improper opinion that if the jury was persuaded by that juror to accept some of the testimony that was put on by the prosecution and to credit or bolster the testimony of the expert witness on memory recall that was put on by the prosecution, that's a problem. And then you'll be right. And the way to get to the bottom of it is Judge Nathan, Allison Nathan, who we've talked about, soon to be on the Second Circuit, is going to have to get to the bottom of this with an evidentiary hearing now that the motion's been filed. She will be interviewing jurors. She will be finding out if what happened in the room, what was said, and how that may or may not have impacted or influenced individual jurors and the collective of the jury's deliberation process. If she finds it was not a great thing to have happened, but did not overwhelm or overcome the deliberative process, then she's going to find the new trial is improper, and Ghislaine Maxwell is going to be sentenced up to 65 years for sex trafficking. If she finds that on the balance, and here I think it's going to be I'm going to ask you your opinion. I think it's going to be a preponderance of the evidence standard, not clear and convincing, and for her to determine whether the jury was severely impacted. If I'm right about that, she won't poll the jury. She'll interview the jury one at a time in a closed courtroom under oath with the prosecution there again, the defense there again. And apparently juror number 50 has retained his own lawyer. So juror number 50's lawyer is going to be asking questions too. And the judge is going to get to the bottom of it and make a decision on that record that she's now developing in this post-trial evidentiary hearing proceeding is going to be part of the record that's going to go up on appeal, regardless of what her decision is. Either the prosecution is going to appeal it, or certainly the defense is.
So what do you do if you are a good prosecutor here? Exactly what the prosecutors in the Southern District of New York are doing. They can't control things they can't control. They couldn't control what juror number 50 is doing, but they take a realistic approach. They recognize that juror number 50 filled out the form incorrectly, but what they try to convince the judge is that juror 50 may have went out and spoke to the press and had these kind of puffery-like statements to kind of puff that individual's chest that they were this powerful and persuasive person. But in reality, Your Honor, this juror did not impact anybody. Go ask all the other jurors. This was a person who just wanted some attention afterwards, which we acknowledge was wrong. But at the end of the day, that was harmless error. That is what the prosecution is going to
1,000%. And it's really going to come down to I think this was a jury of 12. It's really going to come down to the interviews under oath and the cross-examination led by the judge as well. She's going to ask questions as well. And she's going to say, talk to me about the deliberation process. Talk to me about juror number 50. What did he say exactly? And this is going to be a little Rashomonic because we're going to get 12 different versions, and they're not going to be exactly the same, about what juror 50 did in that jury room, and how it impacted the individual juror 1 through 12, and how it impacted the entire process of the deliberation. And the judge is going to remind the juror that she interviews one at a time, this was your jury instruction as it relates to the evidence, and you being objective, and you only making a decision and reaching a verdict based on the evidence that was presented and your estimation of it as the finder of fact under the law that I gave you in the instruction. Did you do that? Or can you say with confidence that you were influenced, you would not have voted for conviction if this juror 50 had not said whatever juror 50 said? And look, there may be a couple that say, I was on the fence until I heard from juror 50. We're going to see how important the memory recall was as an issue in that 6-week trial.
Popok, when you use some incredible terms, I may just need as a going forward basis on Legal AF just to point it out. Rashomonic, all right? That
Salty's going to do a graphic tonight.
Rashomonic, for those who don't know, it's based on the film directed by Akira Kurosawa, psychological thriller crime, a classic. And it basically uses these flashbacks where they reveal the complexities of human nature as 4 people recount different versions of the story of a man's murder, and it goes back and forth.
And a sexual assault. There was also a rape and 4 different versions of that, and they're just completely different. And so the phrase Rashomonic means nobody's memory here. It's ironic we're talking about memory and recall again. Nobody's memory is completely perfect usually, and so the judge is gonna have to piece together 12 different versions of what happened, and then having heard the evidence and, as you said and laid out so beautifully, the arguments of both the defense and the prosecution, she's going to have to make a ruling. That's what judges get paid to do. And then from there, one side's going to be pissed off and not agree. That record now with the post-trial, of all the post-trial evidence that's developed, is now part of the record that's going to go to the Second Circuit.
Two other Ghislaine Maxwell stories. And I guess just to put a little fine point on why we talk about Ghislaine Maxwell, oftentimes at the beginning of these Legal F shows, our first story is not necessarily an overtly political story. It may have political undertones, but it's to provide a learning vehicle for all of you listening and watching, because the same analyses, the same processes that you see we go through in the judicial system with a case like Ghislaine Maxwell's in the Southern District, issues of conviction, sentencing, bail, these issues repeat themselves in the political context. So it gives us a way to kind of teach you about these areas of law while focusing on cases that are in the headlines. And this other update on the Ghislaine Maxwell is that Ghislaine herself has agreed in a lawsuit that was brought by one of the victims of hers and Jeffrey Epstein, Virginia Giuffari, to release the names of 8 John Does. In certain cases, individuals can petition that their names be kept confidential. There are sometimes in cases where there are victims of sexual assault on the plaintiff side. So a victim like Virginia Giuffari may not want her name out there. And there are laws and rules in different states that would allow someone like Virginia, and this is not the case here, she wanted her name out there right now, but in the past she may not have wanted her name out there, where someone could petition to be a Jane Doe or John Doe who's a victim of sexual assault, where their name doesn't actually have to be on the complaint and nobody knows actually who the filer of that lawsuit is. This is an interesting one because on the defense side, these are individuals who were alleged to have been co-conspirators of Jeffrey Epstein, who wanted their names to be John Doe names, and there's about 6 to 8 of them. Previously, in connection with this litigation, we had Ghislaine Maxwell not wanting these names to be released, and she was actually fighting to keep them secret. And Ghislaine Maxwell said, "I really don't care anymore. It's an issue between the individual men who want to keep their names confidential and the court." Anything to add on that one, Popok?
I don't think so. I think you got it right. I think that Prince Andrew's in a world of hurt. The royal family has already moved to defrock him and take away most of his titles, as they're putting him behind a bomb shield before the bomb goes off. He's losing at every turn in the Southern District in front of Judge. He just
lost the motion to dismiss that he filed. Yeah. We talked to our legal AFers last week. He made 2 arguments. One, he made a jurisdictional argument that Virginia Giuffari she lived in Australia now, so she can't file in New York. The judge rejected that. There was also a settlement agreement between Virginia Giuffari and Jeffrey Epstein from many, many, many years ago that purported to release claims against Jeffrey Epstein and, quote, all other defendants. And even though Prince Andrew was not actually a signatory to this agreement, he tried to claim that the all other defendants applied to him. And the judge said, no dice, we're proceeding to the next step. Those are all issues you could raise at a trial, but I'm not dismissing this case.
Yeah. You got 2 judges. One is handling the Dershowitz case that's brought by the same person. And this one is the one brought against Prince Andrews. But I think Judge Preska, Loretta Preska in the Southern District of New York, is going to expeditiously move this case forward now. And, we'll see a trial probably at the end of 2022, 2023, if there's not a settlement earlier.
All right, let's get into politics. We talked last week about Oath Keepers being charged with seditious conspiracy. It was the first time in connection with January 6th, the seditious conspiracy charges were brought. We've heard those talking points from the radical right-wing extremists like Tucker Carlson and elsewhere. Well, name me someone who's been charged with seditious conspiracy. Well, now there has been seditious conspiracy charges. One individual, Edward Vallejo, he was an oath keeper who was indicted last week on charges of seditious conspiracy to prevent the transfer of power from Donald Trump to Biden. He's now been ordered by a magistrate in Arizona, who he appeared before this past Thursday, ordered to be detained pending trial. Edward Vallejo argued that he should be released. And one of Edward Vallejo's main arguments was, look, you just arrested me now. You knew what I did, months ago. You let me, be free then. So why now all of a sudden is it a major issue? One of the things the prosecutors pointed out is you are still out there every single day tweeting in support of the January 6th insurrection. So one of the things that the judge pointed out is that Vallejo was showing no remorse whatsoever. And so Vallejo is represented by a federal public defender. This is someone who's appointed for individuals who can't necessarily afford a lawyer of their own choosing. The federal public defenders, they got tough jobs to do. Like, the federal public defender is not someone who likes Edward Vallejo. It's just his or her or their job to defend whoever is before them, whether it is a terrorist, whether it is an insurrectionist, or whether it's a DUI, defendant, or runs across the gambit.
The mastermind of the World Trade Center bombing had a federal public defender. The Oklahoma City bombers had a federal public defender. I don't want to live in a country where the other side, who is innocent until proven guilty, even with an overwhelming amount of evidence in the public record, doesn't have a federal public defender, state public defender, or you and I, a private citizen that's maybe either doing it pro bono without charge because of the importance of having representation, or doing it for a fee. I don't want to live in that society. There's a name for those societies. It's called North Korea, China, Russia, Burma, those kind of places.
And Popok, one of the tweets that came out of this oath keeper, he said that I'm quoting right now.
I love Twitter.
He said on Twitter, the real insurrection happened in the wee hours of November 4th, 2020 was one
election day
that he said.
Right.
Exactly.
Right.
Another tweet was this. This was another tweet.
Yeah.
I have news for you. You will never achieve vaccine equality as long as I and others like me are alive. I will die first, and that's only when I run out of ammunition. And this particular individual, Popok, he was someone who allegedly, although it seems to be more than just allegedly, but until someone's found guilty, I'll still use those terms. He shuttled a large cache of firearms and other weaponry into Washington, D.C. I think they kept all of these guns and bombs in the Comfort Inn, and they were ready to bring those weaponry and bombs to bear if an order was given by some other oath keepers. That order was never given because everyone was able to storm into the Capitol.
Yeah.
But that's who this Vallejo is.
Yeah. So I'm going to use this segment, which is consistent with what you just said earlier about the Maxwell, to sort of teach our listeners and followers about magistrate judges, Article 3 judges, and the sentencing process. And then, of course, that'll be part of our toolbox that we'll use in future legal AFs for our legal AF law students. And to remind everybody, we have a total of 20 oath keepers who have been indicted on 2 separate indictments. Well, the one that got a lot of press 2 weeks ago that you and I covered was Stuart Rhodes, the founder, the one-eyed, the guy with the patch who shot himself in the head, and that's how he ended up being blinded. But the Stuart Rhodes, the leader, founder of the Oath Keepers, and 10 others have all been indicted federally by the U.S. Attorney's Department of Justice and on charges of, as you said, seditious conspiracy. And the New York Times today, using the federal indictment, did a very nice job, and I commend everybody to the New York Times today, to a timeline of not only the involvement and how each of the 11 were involved, but starting at minus 62 days before Jan 6th, all the way till the day after Jan 6th, and what each of their roles are in the indictment, including Edward Vallejo, who is basically, as you said, the ammo holder, the cash master, who had everything ready to go, all this weaponry ready to go and to be brought in at Stuart Rhodes's command. So he was his munitions leader or chief. And now, and then you have another 9 oath keepers who are being indicted, not for seditious conspiracy, but for obstruction, that big O obstruction charge that gets you 20 years, which is one of the highest counts that you can get under the federal prosecutions that are going on in the District of Columbia. The Edward Vallejo lives in Arizona, so he was arraigned in Arizona, meaning he was brought to make a first appearance in a criminal proceeding in his home state. In the federal court process, you have federal judges who are what we call Article 3, referencing the U.S. Constitution, Article 3 judges, who are appointed by the president and confirmed by the Senate. And that's a process that's been going on now. And we've talked about Biden having a good track record this year of getting diversity and equity and the numbers onto the federal trial level and also at the appellate federal level, just not the U.S. Supreme Court yet until Breyer retires. The federal magistrates are not Article 3 judges, and they're a step right below in the process. They apply for the job. They are not appointed by the President of the United States. They are selected through a process, but they handle a lot of, both on the civil side, where Ben and I practice primarily, and on the criminal side, they handle a lot of the day-to-day administration of justice. So a federal magistrate will often be the one, depending upon the size of the federal district and how many cases are going through it, will handle a fair amount of the arraignments, first appearances, pretrial detention motions, determining whether the person should be detained pretrial, and then even bail and bond. Now, sometimes they do it with a report and recommendation to the federal Article 3 judge, and sometimes they just have the power to do it. Just depends on the type of proceeding that we're talking about. Here, Vallejo, with a federal defender appointed to him, comes before a magistrate who makes the ultimate decision whether this particular person is going to be detained pre-trial. We talked a lot about that when we were talking about, all of the Jan 6 subpoenaed people that are refusing to appear, and the prosecution of people like Bannon. And I know a lot of our legal AFers were like, why isn't he detained pre-trial? He should be. He's disgusting. And we all agreed about that. But if you look at the federal detention rules that have to be applied, he didn't really fit the bill. This guy jackpotted himself into fitting the bill because of tweets just the way that you outlined them, Ben, which he did while after arrest and before the arraignment. He starts threatening the World Health Organization leaders, referencing violence and ammunition, starts talking about the insurrection. So his federal public defender said, Judge, he's been a good boy for the last year since he was arrested and released. And if he was going to do something bad, the federal government let him out. And so they can't have it both ways. I mean, I thought there was a unique argument by the federal public defender, i.e., my guy hasn't bombed anything lately, and the federal government let him sit on his couch. So what's the problem? Federal government, of course, prosecutors brought in all the tweets that he's done and laid out this guy's role as the ammunition master of the entire plan. The only reason he didn't bring the ammo, as you said, into the Capitol is because they were able to, overrun the Capitol Police without firing a shot. But if they couldn't, Stuart Rhodes was ready to give the command. And the conspiracy to do something doesn't mean that the objective was ultimately achieved. You can have a conspiracy to commit murder without having murdered the person. So the fact that he says, all my stuff, all my ammunition stayed at the Comfort Inn, that's not a defense to conspiracy. So now he seems to be the first one of the 20, or at least the 11 with Rhodes, that's coming up for pretrial detention hearings. But I think a lot of them are going to be detained pre-trial, including Stuart Rhodes. I think Vallejo is the first of many, and we will report on them as we get new information.
Popok, as you talked about Biden's judicial appointments there, when I said he's made great judicial appointments, people from diverse backgrounds, bringing diversity to the bench, bringing women to the bench, which is so critical and vital in our judicial system, that it's not all white men on our judiciary. And I have these flashbacks of the Trump appointment processes and the confirmation hearings before the Senate of all these unqualified white males. And when I say unqualified, from bipartisan groups at the American Bar Association, who says that these individuals who Trump nominated and people who were appointed never did a deposition and never did a trial. Why I'm bringing this up is, from time to time, people who I don't talk to for many, many years, or in some cases decades, who have gone down this Trump rabbit hole will send me a DM on Instagram, like completely out of nowhere, or shoot me a text message. And so yesterday I got a DM from this person who I haven't spoken to probably 11 years, who sent me something from Conservative Review with Republican Senator Kennedy. And this is what it's titled. Senator John Kennedy slams Biden nominee and embarrasses her. And they're talking about a nominee named Jessica Clark, who went before the confirmation hearing. Let me give you Jessica Clark's background. She began her career as a law clerk for Judge Solomon Oliver Jr. of the United States District Court of the Northern District of Ohio from 2008 to 2010. From 2010 to 2016, she was a trial attorney in the Housing and Civil Enforcement section of the Civil Rights Division of the United States Department of Justice. So fighting for fair housing rights as a trial lawyer. She did trials after trials and has trial experience. She worked at boutique law firms, and then she served as the chief of the Civil Rights Bureau at the New York State Office of the Attorney General, with work including violations of federal, state, and local civil rights law to fair housing and addressing police reform. And so she comes from this diverse background. She has this experience as a trial lawyer. And she was asked the question from Senator John Kennedy, when he does this like aw shucks routine where he's like, can you tell me what a 10b-5 lawsuit is? She answered the question, and she said a 10b-5 lawsuit relates to fraud, but I don't practice in that specific area, Senator. And he goes, so you're telling me that you don't know what 10b-5 is, and you are going to be a judge on the Southern District of New York? Let me tell the people who are listening to Midas Touch Legal AF right now, lawyers don't know every aspect of law. There are billions of areas of law.
Other than you and me.
we do actually have a big varied background here. But as she said, I will follow the precedent. I will delve into the cases. That's why judges have lawyers brief the issues, and a good judge reads the issues spots, and makes the rulings. But you want someone who has trial law experience. That's exactly who you want. That's what I told the person when they sent me the message. And of course, they were radio silent.
Yeah, of course. Yeah, they only pop up out of the troll village for that one little comment. Now, look, when I was a kid and I wanted to be a lawyer, I was like 11 or 12. I thought about it. I thought that a lawyer had to memorize and have at the top of their head, the index of all statutes and laws. And I was like, wow, that's a daunting profession. I wonder if I'm up for it. What I realized later is when you go to law school, while you and I did learn a fair amount of law, including you, I'm sure you and I could have a competition to name cases just off the top of our head that we learned in law. They're drilled in, that are burned into our memory. However, that's not what you do in law school. That's not what you're doing in legal AF. What you're learning is how to think like a lawyer, how to organize your brain in a way to be logical, organized, be able to use the Socratic method, be able to drill down on new and interesting ideas, topics, subject matters. One of the reasons I became a trial lawyer or a litigator, and this might resonate with you, Ben, is because I wanted case by case to learn different areas of the law, become expert in them, different areas of industries and segments of the industries. Every one of my cases that I'm handling right now, I've got about 30 cases around the country. Every one of them is different under a different body of law in a different industry. And I love that. I've always loved the mental challenge to be able to become expert and do subject matter mastery, but not because I went into it, I knew it going in. That's not what a judge has to do. What you're looking for in a judge is somebody who has a nimble mind, who is an intellect, who can drill down and learn those areas through the briefing, through the law, through the assistance of law clerks, not getting a pop quiz from some, foghorn leghorn, Warner Brothers cartoon character who's sitting as a senator from, where is he? Mississippi? Somewhere?
I go find that for you right now in a second. But
right. But it is beneath the process to do stump
Louisiana
the candidate. Louisiana, to do stump the candidate. Most candidates would say, I took securities law in law school, which is where 10b-5 comes from. I took securities law, Mr. Senator, but before I rule on a matter, I'm going to fully understand all the law that's involved, both from the briefing and my own independent research, along with my clerks, and I will render a fair, just, and unbiased decision. That's the answer. I'm sure she gave some version of that back to him. But this bullshit of, especially, was she a person of color too, or I would say just a woman? Was she a person of color? Yeah, it is these microaggressions and this racism and misogynist approach. He would never do that to a white man. I bet you if you go back in the history of his asking questions on that panel, he's never done that. And he certainly hasn't done it to the unqualified group of men that Trump appointed, 40-year-olds with no trial experience, whose only
deposition experience,
never took a deposition in their life. Tons of them have been put on a federal bench. I scratch my head. 12-year lawyers. They're barely formed. They're infants. And now they're sitting as federal judges. But that was misogynist. That was racist. That was anti-woman. And that was beneath the process. And hopefully he was chastised for it by his fellow, at least Democratic senators.
Also just sucks that his name is John Kennedy. He should just go by JNK.
That's another thing.
John Neely Kennedy. He's no Kennedy.
He's not a Kennedy. I know JFK, and he's no JFK.
We have a lot to talk about on the podcast today. Of course, we're going to talk about the Supreme Court's ruling relating to Trump trying to prevent the documents relating from January 6th, which are housed at the National Archive, from being turned over to the January 6th committee. I'll give you the spoiler alert. The Supreme Court, in a 8-1 ruling, ruled that those documents would go to the Jan6 committee and did not issue an injunction.
Who was the one, Ben?
Clarence Thomas, and we'll go into that later. And when we talk about that with Clarence Thomas's wife, we'll talk about that then. But first, I want to talk about one of this show's partners, Masterworks. This podcast is brought to you by Masterworks. So let's just take a break from news talk for just a nanosecond, because believe it or not, breaking news doesn't have to be about the latest court decisions, drama on Capitol Hill, or Web3, whatever that is. In fact, here's some tech news you might have missed, and it has to do with, get this, Popok, fine art. Did you know that a Picasso painting sold for over $100 million at an auction last year, marking a 1,400% increase from its original price? That's a 1,400% increase, which is shocking. But when you learn that blue chip art price appreciation has outpaced the S&P 500 for over 2 decades, and that the Wall Street Journal deemed that the art market was one of the hottest on the earth, you can see why it doesn't take a computer scientist or Legal AF host to see that blue chip artwork might be one of the smartest investments that you can make in 2022. And thanks to Masterworks, now you can invest in blue chip artwork without having a Bezos-sized bank account. They're this fintech unicorn democratizing the art market, enabling you to add fine art to your portfolio without being a millionaire. I'm talking about paintings by Banksy, by Basquiat, by Picasso. Don't get nipped in the bud by Bitcoin when you can be investing in works by iconic artists like these. Our listeners can receive priority access to their newest offerings. It's really cool to say, I own a Banksy, I own a Picasso. So get started at masterworks.art, ART/legalAF. It's not .com. So you go to masterworks.art/legalAF. That's masterworks.art/legalAF to find out more and see important disclaimers at masterworks.io/disclaimer.
Popok. I love fine art. I'm a big, look at this painting. Now, as long as we're on to paintings, I want to get something quick in the chat for tonight because it keeps coming up. This painting behind me is not crooked. I know everybody says it is an optical illusion. It's because my camera is on an angle. We have looked at this. I have actually glued it to the wall at Bubble. It is straight. It's if you think it's crooked, it's either my head or the camera, but it's not the art. Okay, Ben.
Okay, so going into the news, I'm glad you cleared that up, Popok.
Yes.
A lot of controversy
Comes up a lot.
Swirling the United States, swirling Micronesia, where we're the #1 podcast in all of Micronesia, and swirling other areas where Cyprus, we are the #2 podcast in Cyprus. So thank you to everybody.
It's beyond my wildest dreams. I pinch myself every day.
In Cyprus. As we go on to more stories, Popok, legal stories, we talked about this on the last podcast, and this is the issue of the phony elector slates, these certificates that were prepared as part of the coordinated coup plot led by Trump, and different states were putting their own, these are Republican legislatures. These are like legit people, like even though they're, they've gone down the QAnon rabbit hole. Let's say this, they hold legit titles like state senators, but these are people who prepared alternative electoral slates that they were going to send to the National Archive for processing, from the National Archive to Congress. And so when the electoral votes would be certified based on the plan that was a coordinated conspiracy with people like Senator Cruz, with people like Senator Hawley, who were objecting to the electoral slates. Popok's got, what is that, a legal AF cup that you got there? Is that
one that I just made during your introduction?
I like that you made a legal AF cup with pen. Very scrappy over there, Popok. But this was a coordinated effort to, then they were going to, when there was doubt that was going to be cast by these objections to the actual the legitimate electors, then what Trump wanted Pence to do was hoist up these other electors that were given by these Republican, Republican GQP states that were trying to put forward their own electors. And there was no governor or secretary of state that went along with it. Thankfully, for this last election, for the upcoming elections, one other thing that Trump wants to do is take away any power, really, that governors and secretary of states have, vest that power purely with the radical right extreme state legislatures, so these fake electoral slates can actually get into place. And we kind of knew about these electors a while back, but it kind of seemed so far-fetched to even be taken seriously because these were like literally forged documents that they were creating. It's like, what the hell is going on here? And now we also learn, of course, Rudy Giuliani was one of the people coordinating on behalf of Trump with these forged electors. But a lot of state AGs are asking that prosecutorial action be taken. There's 5 states in particular that went all in. These Republican legislators that try to elect their own electors. There were 2 that kind of hedged a little bit that said,
them. That's what if I was a fraudster, I would hedge like Pennsylvania and New Mexico.
Yeah, the Pennsylvania. So break this down a little bit more for us.
Yeah,
Pennsylvania, New Mexico, some of the other.
And by the way,
states.
shout out in a weird way, evil shout out to Rudy Giuliani. He's like the Energizer Bunny of fraud and forgery and conspiracy. Thing, an
evil shout out? Can you do
it's
that?
An evil shout out. He's involved with every effing bad thing that happened.
You know what it's like,
Popok? Forward.
People may have no clue what this reference is, but there's something going around TikTok now of someone called West Elm Caleb, and he used this dating app Hinge, where he basically did the same like ghosting routine, love bombing routine with every single woman in Manhattan, where all the women were like, wait a minute, you know West Elm Caleb? So Giuliani is the West Elm Caleb of fascism.
Is he West Elm because all of his furniture was West Elm?
He works at West Elm, apparently.
He works at West Elm. Even better. Okay. Yes, West Elm Giuliani. So let's start with fake electors. Where'd they get this idea from? So some numbnuts, some lame half-wit came up with the concept from Hawaii, which was a state, in 1960 during the Kennedy versus Nixon election. What happened there? Very close election, as people probably recall, between Nixon and Kennedy. Kennedy obviously prevailed in the 1960 election. And it got really close in one state in particular, in Hawaii, came down to like 200 or 300 total voters. So there were some legitimate people in Hawaii for Nixon that got together as a slate of electors, an alternate state of electors, signed some certificates, making it clear, not forging anything, making it clear that if after a recount, it is determined that Nixon has won Hawaii instead of Kennedy. In other words, Nixon finds 201 votes somehow. This would be the slate of electors for him, and they sent it in. Well, these idiots decided, let's do the Hawaii 1960 stratagem, but let's forge our documents. Let's send them to the National Archive. Let's send them to the election officials in 5 different states and act like these are the real, including, seals and signatures and language, all probably written by Rudy Giuliani, because that's now come out in CNN reporting. So the 2 states where they had a little glimmer of conscience and decided maybe they're committing federal crimes and they don't want to go that far, as you alluded to, Ben, was Pennsylvania and New Mexico. There, they changed the template, the form document that probably Rudy created. And theirs, they typed in instead that if it is determined by a court after final appeal, that Trump has beaten Biden, if that, then I'm an elector. Here's my slate of alternate electors. You and I actually heard about this back on the Jan6 itself. There was just so much chaos in the form of an insurrection and a riot going on that it sort of got lost in the shuffle. Ben, do you remember that when Pence was announcing each 50 state, he had this weird phraseology that was not part of the script that every vice president has used for like the last 100 years. All of a sudden, he started talking about, and I have checked with the rule maker for the House of Representatives as to another set of electors, and that will not be recognized. Only this as the official. Do you remember that Pence comment? We were all like, what is he talking about?
Yeah. No, he was saying, and this is
what's he talking about?
Legitimate signatures from the seal.
Right.
It was this whole, rant. And look, Pence is the most spineless coward. Oh, yeah. But what he was the central figure to the plan. That's why. Look, that's why it's fucked up to say it, but that's why they wanted to hang him, and that's why Trump and a lot of the right wingers were encouraging people to kill Pence. Let's not sugarcoat what it is.
Well, he had to accept those phony electors in the 5 swing states in order for this plot to work.
But just take it back for a second. There are so many people in Trump's orbit who would have actually done that, who would have accepted the fake electors. No, I'm saying in Trump's
1,000%.
who would accept the fake electors.
Who was the fat guy that was the Secretary of State?
Yeah, Pompeo and
Pompeo definitely would have done it.
Yeah. You know, Pompeo's lost a lot of weight too.
I know that's why I said that.
You know, since then, and good, and you know, I mean, he's a bad dude, but also, you know, good for him for, I guess, getting healthy after the Trump. But I think Trump would make you a very, you know, unhealthy person. But I shouldn't say good for Pompeo on anything. But yeah, Pompeo would have allowed the fake electoral slate to go on, and then just think what would have happened. Our country would have been in a civil war. Our country would have been thrown into massive chaos.
Yeah.
That's what would have happened. That's why it was a coup attempt, and we need to call it what it is. But back to you, Popok. Other Giuliani news, though, that I want to talk about. So the short of it, there are, in the 5 states, there are multiple AGs. We talked about the AG of Michigan, and other AGs like that who are looking into criminal referrals and potential criminal prosecutions around those who are involved in the forging of these fake electoral slates. And that's heating up as a serious issue. The other issue on Giuliani was, we talked many dozens of Legal AF ago about the raid of Giuliani's apartment. His electronics were seized. Giuliani said, "You can't seize it. This is my work product, my attorney-client privileged information with Donald Trump. I am his president," although apparently Donald Trump didn't pay Giuliani any money. I need an update on that one to find out if Trump actually paid any of Giuliani's bills, because I remember there was a story about a month ago that Giuliani claimed, or 2 months ago, that he wasn't even paid at all by Donald Trump, which just makes the whole thing ever more baffling. But the issue over attorney-client privilege communications, the communications between an attorney and their client under law and precedent is deemed to be confidential. We want clients to have candid discussions with attorneys. So that means in legal cases, criminal or civil, you can't ask for those communications, or if you ask for it, an attorney would object and say, that's my attorney-client privileged communications. But with every privilege, there are exceptions. First, the communication has to be in furtherance of the attorney-client relationship. So it can't be like outside of that. It has to be actually an attorney-client relationship. And there are exceptions, like a crime fraud exception. An attorney can't aid and abet a client in criminal conduct and then say, hey, you can't get into that conduct. It's attorney-client privilege. There's also issues of waiver regarding attorney-client privilege. So if the client who holds the privilege with the lawyer starts writing books about it, is this the case sometimes with Mark Meadows? That wasn't an attorney-client privilege. That was an executive privilege issue, but the same concept applies. You waive the privilege by talking about it publicly, because you're saying that relationship between me and my attorney, if you're going to talk to friends and the news and the media about it, well, you could talk to courts about it and opposing counsel about it. So Popok, tell us what happened here with the special master, what a special master is, and what the ramifications are with these Giuliani documents.
So back in April, you and I talked about, Scott, seems like a lifetime ago. You and I talked about the raid on Rudy Giuliani that was executed by the FBI on behalf of the Southern District of New York's and the Department of Justice, or the U.S. Attorney's Office here in the Southern District of New York. Why is that so earth-shattering? Because Rudy Giuliani used to be the U.S. Attorney for the Southern District of New York in his own office. In a dawn raid, decided that he did not deserve the opportunity to turn in these items by himself, and they were going to take it out of his hands. So they grabbed 18 devices, and you and I joked at the time, Ben, even you don't have 18 electronic devices, do you? That you can use for communications or otherwise. I got 2.
I got 1.
You got 1.
What's that song? I got 2 phones. I won't say the rest of it, but
yeah,
I got 1 phone.
Yeah. All right. I got a phone. I got a laptop. That's about it. So he had 18 devices. He's either a pack rat of the first order, or he likes using burner phones and forgot to burn them all. So he had them on the day of the raid. So people might be thinking, well, April, May, June, July, August, or 7-8 months later, why haven't Ben and Popok updated us on that? Because there was nothing to update on. The judge that's overseeing the prosecution of Rudy Giuliani, again, for the issue of whether he was an unregistered foreign agent on behalf of the Ukraine in his role in trying to throw out the U.S. ambassador to the Ukraine and other things related to diplomacy that the president was allegedly trying to conduct with the Ukraine. So they're focused on whether he violated this criminal act.
I wouldn't say it was diplomacy. I would say he's trying to extort the president of Ukraine.
I'll give you $450 million worth of arms if you start an investigation against Hunter Biden and Joe Biden about Burisma. And the Ukraine was like, hello, what? Sorry. It sounded like you're trying to extort me with weapons that have been approved, whatever. So this Giuliani is all part of that. And there's some other related things you and I have talked about that are all sort of tied into this web of the Ukraine, including Igor Fruman, including others one just got sentenced to 1 year and a day in jail this past week, which is Igor Fruman, related to this Ukraine conspiracy. There's another one that you and I have talked about that hasn't yet been sentenced. In any event, a special master, you mentioned that earlier. What is that? People are saying at home. That is when a judge usually has the obligation to do what's called an in-camera, it's a Latin term, in-camera review to determine whether, for instance, privilege applies or not in documents that are going to be exchanged between the parties. That can happen in a civil case. That can happen in a criminal case. So that in-camera review is either done by the judge themselves. They literally look at the documents, making decisions about the privilege, application of the privilege. Generally, in a civil case, the party is obligated who wants to preserve the privilege, is obligated to produce and prepare a privileged log, LOG, which is what it sounds like. It's a spreadsheet that lists the document, the unique serial number that's been assigned to that document in the case, which you and I call BATES, BATES numbers, and the privilege that's being asserted, and the judge goes line by line, document by document to determine the application of the privilege. That takes a lot of time, especially when you have tens of thousands of pages of documents. So the judge can turn it over to, if you're a federal system, a federal magistrate. That is a non-Article 3 judge we talked about earlier. But if the project is so voluminous that even that would overwhelm the federal magistrate, then the judge can appoint a special master, which is a private lawyer and a firm behind them who is hired for that particular task. And that is usually paid for. Well, first it's paid for by the Department of Justice at some hourly rate or negotiated rate. But ultimately, the Department of Justice will try to get it back from the person who's being prosecuted if they are successful by way of a fine. So this is probably costing, I'm not making this up, $1 million or more to review all of these properly and to issue a report and a privilege log analysis back to the judge to make a decision. Who was hired to be the special master? You may be asking, Ben, go ahead, ask me.
Who would be the special master on this one, Popok?
Do you know who former Southern District, New York federal judge Barbara Jones is? Does that sound familiar?
It sounds familiar now.
Do you know why?
Tell me why, Popok.
She was the special master for the Michael Cohen case. So she reviewed all of Michael Cohen. She was hired by another judge. She's a former federal judge that now is a private lawyer with a big law firm. She gets hired for these things because she's got an impeccable set of credentials and being a former judge and all of that. And so she did the Michael Cohen review of all of his data and information for his particular prosecution. And she just did it for Giuliani, resulting in 3,000 messages being turned over to the Southern District, New York office of the U.S. Attorney's Office by former Judge Jones and her team, and a report back to the judge. Now, let's not get too excited. I want to manage expectations. From what the earlier reports are for people that have seen it is there's very little, if any, communication between Trump and Giuliani. Trump is notorious for doing everything on the phone and not doing anything by text on purpose so he wouldn't leave a paper trail. So I would be shocked if there's any Trump communications between Giuliani and Trump in any of this data that was collected, because that's all going to be testimony of people that heard the phone call, that were on the phone call, the recordings that were made in the White House, because everything that's actually done and conducted in the White House is supposed to be done through recorded lines, but it's probably not going to come from these texts. But what a fall from grace, just reiterating the tremendous fall from grace for Rudy Giuliani. I mean, not only is he involved with all these efforts to overturn a fair election and in a seditious way, but here his own office is prosecuting him for violating the Foreign Agent Registration Act. Really, a really sad comeuppance for this person, all based on his own behavior. He didn't. None of this is accidental. It's all based on his own decision making, usually for greed and for profit, to throw his lot in with President Trump.
Absolutely, Popok. And I've asked people to do psychological analysis of Giuliani. There's obviously a profit and money motive. A lot of people have told me he's also just someone who wanted to kind of stay relevant. And so he threw his lot in with the fascist lot of Trump and others, just so he could be, in the action, and got deeper and deeper and deeper into it. There's another kind of less psychological analysis. There are a lot of people and sources I know who are very close to him, and it's a serious issue, to talk about, but it's one that I've heard is that he also drinks very heavily and does a lot of the types of conduct that we see when he's inebriated.
I wouldn't be surprised by that. But you know what all this conversation about lawyers and clients reminds me of?
What?
It reminds me of our new sponsor for today, which is Smith AI.
Tell us about Smith AI, Popok.
This is Smith AI. It is. It's about clients, because without them and without support staff, you and I would not be able to have a successful law practice or even run a podcast. Clients demand instant response, but now more than ever, businesses are spread really thin. I know you and I are. If you're losing leads from visitors to your website or missing calls that could grow your business, that new client, Ben, we missed the call, we can't get them in, then you need to delegate those frontline conversations to the best virtual receptionist service around Smith AI. This isn't AI like receptionist, like robot receptionist. These are live, actual human beings who serve as receptionists. And Smith AI provides businesses with award-winning virtual receptionists who handle your calls, your chats, and text to unlock new business at a fraction of the cost of hiring an in-house staff. Smith AI is not your average receptionist service. Since 2015, they've combined the best receptionists across North America with AI technology for superior business communications and customer engagement. They're friendly and professional agents who are bilingual in English and Spanish, can screen leads using your custom criteria, schedule appointments on your calendar, and call back leads who complete your form. They can do it all by phone 7 days a week, and also on their website through their 24/7 live chat service. They even answer text and Facebook messages. See, that guy that wrote you, Ben, who DM'd you, Smith AI could have responded to him instead of you. They integrate with your preferred software, whether you use Salesforce or HubSpot, Calendly, Zapier, and thousands more. So even though you're not involved in every call, you're always in the loop. In other words, you don't have to use Smith AI software, you use your own, and they integrate with that. Plus, they have English and Spanish-speaking receptionists, as I mentioned, and will block spam for free, including all those annoying sales calls. They handle those calls after hours, and they have been helping thousands of small businesses across a wide range of industries, including law firms, home service professionals, marketing agencies, and other service-based businesses, and they're ready to help your business too. So work uninterrupted, run your business with less stress, and get more leads from your marketing efforts. And you'll see that Smith AI pays for itself and then some with all the new clients that your receptionist will help you win. Plans start at just $240 a month. I was blown away with that number when they told us about that. I think that's a very reasonable number. So try Smith AI today and see for yourself why business owners like Justy Nicole says Smith AI receptionists are her secret business growth and client, her secret to business growth and client happiness. And our listeners will save $100 when you sign up by using our promo code LEGALAF, LEGALAF at smith.ai. So visit smith.ai to read 5-star reviews, and be sure to use our code LEGALAF, LEGALAF, to save $100 at sign up. Don't let another day go by. Try Smith AI.
Popok, great ad read. And as you were doing that ad read, it reminded me, I got a message from some members of the Meidas Mighty. You know, after we do the podcast today, we actually have a Meidas Mighty meetup in downtown Los Angeles. A number of members of the Meidas Mighty on their own organized a weekend in LA. So special shout out to Meidas Jules, Meidas Jerry, Meidas Aaron, Meidas Zobeth C, Meidas Mel, and Meidas Lauren A. Let me show you just some photos for those watching of the Meidas Mighty trip in Santa Monica. I'm putting it up there.
Oh,
pretty cool,
I
right?
like it.
You know, this was from dinner last night wearing the Meidas Touch gear with a welcome package. And it's one of the most humbling things to see on its own organically members of the Meidas Mighty. And I encourage this to go and meet up, you know, safely if everybody's vaxxed and boosted, you know, to meet up and make this virtual community into physical communities where people can take action, whether that's registering voters, whether it is going to school board meetings, whether it's to convincing family members and others either to register to vote or to explain to them what you learn on Legal AF. But I encourage everyone listening, go do meetups, like reach out to other members of the Meidas Mighty in your town, in your city.
New York City meetup. How do we do that?
How do you do it? We just put it out there into the world, Popok.
Let's do it.
We give the positive vibes, and then it happens. But special shout out to all the Meidas Mighty.
Yeah,
and
that's awesome.
After this, I'm going to go and meet up with them at a restaurant in downtown Los Angeles called 10E, the number 10E. And so that'll be interesting and fun. So Popok, want to talk about updates relating to SB 8. We've kind of covered SB 8 for those who don't know is the bounty hunter law, which banned abortions after 6 weeks in Texas. It did this through a very unusual scheme that fined those who facilitated abortions by fining them $10,000 or more. It moved the regulatory structure away from the state, so the state wasn't enforcing it, because that would run afoul for now to Roe v. Wade. Of course, those legal AFers who are listening know that the Dobbs versus Mississippi case, which threatens to overturn Roe v. Wade, there'll probably be a decision sometime June or July. Oral arguments were last month in that issue, and it does not look good in terms of Roe v. Wade surviving. But given that Roe v. Wade is the law of the land, currently, this SB 8 scheme was a way around it, so the state wasn't enforcing it, and that you'd have to bring individual lawsuits under the constitutional abortion right against individuals who were actually suing for the $10,000. And because it was hard to find individuals who were actually suing, the threat of $10,000 for all purposes prevented medical providers from providing abortions and abortion health care in the state of Texas, and made it very difficult to enforce. So this went all the way up to the Supreme Court. The Supreme Court basically allowed SB 8 to remain in place for now. They did say that you could bring certain discrete federal actions, potentially against licensing government entities, but not against other government entities. But the issue then, the Supreme Court kicked it back to the Fifth Circuit Court of Appeals because the underlying case was, again, in Texas. The Fifth Circuit Court of Appeals, which is in New Orleans, hears the cases that are from Texas. The Fifth Circuit is a very radical right extremist court, like the current composition of the United States Supreme Court. And the Fifth Circuit said, well, we need to defer this issue to the Texas Supreme Court about what rights exist with respect to those licensing agents, or whether they're even real proper parties to begin with. And so basically, this whole thing was a coordinated, concerted effort to delay and prevent abortions from happening in Texas and delay a legitimate challenge to abortion care from happening while the Dobbs v. Mississippi case is working its way in the Supreme Court, which is likely going to overturn Roe v. Wade. Did I miss anything, Popok, or did I hit it out of the park?
No, this was all the conservative right-wing members of the Supreme Court and their 6-3 decision to kick this can as far down the road as possible. They must have gotten together and said, how do we push this off until late June, when we're likely to issue the ruling in Dobbs versus Mississippi as to whether a 15-week ban, which is lower than the 23 or 24-week ban for Roe v. Wade, is constitutional or not. And we don't want to decide anything about a 6-week ban or anything else in the meantime. It's all lined up for Mississippi in late summer. And, we're just celebrating this week the 50th anniversary of Roe versus Wade. They're speaking of participatory democracy and the Midas Mighty. There was a march in Washington, a green-hatted march on Washington related to Roe v. Wade. So how do you do that? Well, then you make the people that are in the groups that are trying to overturn SB 8 and the 6-week ban in Texas, you make them jump over every procedural hurdle without being expedited that they can think of. And the monkey wrench that the Fifth came up with is the one you said. Let's kick it off to the Texas Supreme Court to make a ruling on a legal, a sort of very, very nuanced, very who cares decision about whether medical licensing boards are the proper party here or not. That all could have been decided by Judge Pittman, who is the district judge sitting in Austin. And that's what the providers said. Why are you going to do it? We don't need to hear Texas Supreme Court. Let Judge Pittman do it and then bounce it back to the U.S. Supremes on an expedited basis. And the Fifth said, no. Let's kick it off for another 3 or 4 or 6 months and let it run its course through the Texas Supreme Court. So they went back to the U.S. Supremes and said, please force the Fifth to send it to Judge Pittman and take it away from the Texas Supremes. And on a 6-3 decision, and the dissent written by Sotomayor, a very, very passionate dissent written by Sotomayor, joined by Breyer and joined by Kagan, the 6-3, including Roberts this time, which is odd, said, no, we're going to let it keep its course, let it go through the Texas Supreme Court, see everybody in late June when we decide Dobbs versus Mississippi. And Sotomayor came out of the box and said that extending the deprivation of a fundamental federal constitutional right through procedural manipulation is ghastly, uncalled for, and an affront to women everywhere.
So let me break that down, Popok, just in plain terms. Justice Sotomayor was like, what are you doing? We have Roe v. Wade. We know this is illegal. Cut the bullshit and just issue an injunction and say you can't enforce a law that we know is unconstitutional. Cut the shit. That's what she said.
At least send it to Pittman and let Judge Pittman make a record, a proper record that we could try to take back ultimately to the U.S. Supreme Court. But look, the writing is on the wall. They're not going to do jack shit about abortion rights, as you've always said, Ben, and you've been right on this. And I was off. I was slightly right, but not as right as you. They're not doing shit about abortion rights until they make the decision in the summer. And that's going to be a huge, maybe all abortion rights episode of Legal AF when that decision comes out.
They're going to overturn Roe v. Wade. Like, I want to be clear what they're going to do. Like,
but Ben, what does that mean when you say overturn Roe v. Wade? Do you mean that the constitutional right to an abortion at any period of time, any trimester, is going to be outlawed? Or do you mean that it'll be reduced substantially to somewhere in the 6 to 15 week mark, down from the 23, 24 week mark?
Here's what I have a great degree of confidence is what's going to happen. I can't say I'm 100% sure, but reading the tea leaves of the oral argument, the Supreme Court is going to uphold the Mississippi ban on abortion, which is 15 weeks, which is the 15-week ban. Can't have an abortion after 15 weeks. And what the ruling, I believe, is going to say is that states like Mississippi are empowered to make their own analysis, and it will be up to the states to make those determinations on a state-by-state basis. They will use this concept of the fetal heartbeat, which is a concept that was used in the 6-week ban in Texas. There will be dicta to that effect. I'm not sure that will be the binding precedent there in the Supreme Court. Dicta is just some other things that the court said that may not be binding precedent, but I think they'll refer to an example of the fetal heartbeat being a way to make the determination. And so what will come out of that hearing, what will come out of that ruling is that it'll be a state-by-state issue, not to ban abortions generally, but it'll be a state's issue, and states will enact what Mississippi's going to do. What will then happen is Texas will take SB 8 off the books. Texas will say, we don't need SB 8. Why do they not want SB 8 to be on the books? Well, they now have the abortion ban from the Mississippi case, so they'll just institute an abortion ban. They don't need a circuitous kind of scheme like they have with SB 8. They also don't want SB 8 on the books because they don't want non-radical right extremist states to use the SB 8 structure for things like gun regulation of military type weapons on the streets by schools. That's where we are in this.
Yeah, I think you're right. I think that is a very good sort of template for our future discussions. And all we're seeing is that writ large by the Supreme Court's 6 right-wing justices to delay every way they can until they get to the Dobbs decision in June
Popok,
or July.
in somewhat better news, though, the Attorney General in New York, Tish James, is moving methodically on all of her actions against the Trump organization, particularly, though, the civil action. She filed a petition in court this past week. It was like 100 plus pages, 120, 160 page petition to compel Trump, Don Jr., Ivanka, Trump family members to testify. We learned from those filings as well that Eric Trump and Alan Weisselberg and others invoked their Fifth Amendment rights hundreds of times, 500 times in connection with this probe. But she wants their under oath statements, and she put into this filing. And I think this is a headline to carry away, that we have substantial evidence that the Trump organization engaged in fraudulent conduct to inflate the valuations of their properties. I mean, she also has a parallel criminal investigation. So the fact that she's saying that we have that, she's actually
the Manhattan DA's office does.
Remember, the AG's office is cooperating with the Manhattan DA's office in their prosecution.
Right, but don't fall into their trap that she's conducting a criminal investigation. She's cooperating with it, as mainly civil and criminal does, but her office is not conducting a criminal investigation. They are sharing information with the organization, the prosecutorial body that is, but she isn't, because I don't want us to fall into the trap of, oh, look, even Legal AF said she's conducting a criminal investigation. Not that we would be quoted by her lawyers, although at the rate we're growing in our audience, we may be one day be referenced in one of the things that we follow. But did you have more to comment on that before I break it down a little
what's
bit?
Going on there?
Yeah. This was an unprecedented filing by a New York Attorney General Let me put it in context. This does not happen every day. The New York Attorney General, I've been doing this a long time. While they'll do press releases, in this case, she tweeted her press release a couple of days ago, Tish James, they rarely do we get to see kind of inside a pending civil investigation the way we have with this 160-page supplemental verified petition that was filed with the New York State Supreme Court, which is the trial level court in New York. Why do I think she did it? Then let's talk about what's inside of it. Why do I think she did it? She did it for a number of reasons. One, she did it to fire back. She's had it. She's had enough to fire back at Trump, hiring some 3-person law firm in New Jersey to go file some bullshit case in the Northern District of New York to try to get her disqualified several weeks ago. People might be saying, what happened to that case? Nothing, and nothing's going to happen to that case. And New York Attorney General is not going to be disqualified because the target of the investigation thinks that she's being mean to him. That's not a standard, okay? Or mean to the family. Well, she's mean to me, she gets to be removed. That's not how investigations work, and that's not how recusals work or disqualifications work. And this is Tish James, like in full, fighting back in the media, in the press, reestablishing her credibility, to the extent that it took a hit, which I don't think it did, reestablishing the power of her office to say to and also to report to the American people who are wondering, the way they're wondering, what's the Jan6 committee doing? This was Tish James saying in 160 pages that I have looked at, and look at these numbers, Ben. I have looked at 930,000 pieces of evidence that have been supplied by subpoenas by third parties and the Trump organization and their accountants and their lawyers. And I'm going to talk about that in a minute. Remember that number, 930,000. We've had dozens and dozens and dozens of people come in here voluntarily to give testimony. And we've gotten major law firms. Morgan, Lewis, and Bacchius is named in the verified petition. That's a major American lawyer, top 20 law firm, who obviously represented the Trumps. Maser and Associates, which is an accounting auditing firm for the Trumps. Deutsche Bank will get dragged in. She'll get as much from these third parties, like law firms, accounting firms, banks, lenders, counterparties, taxing authorities, as she will ever from the Trump organization. That's icing on the cake. And she's saying to the world, having spent a year reviewing with my team almost 1 million documents and testimony, we have reached some preliminary conclusions about financial fraud conducted at the highest level by Trump, his sons, Eric and Don Jr., and his daughter, Ivanka. And you'll see the breakdown, and we'll post this tonight on one of our Twitters or both. In the actual report, you'll see that it's loan fraud. He inflated assets either in order to obtain bank loans. He deflated the value of the assets in order to avoid paying taxes. He lied about things, just like he lied about the size, Ben, of the inaugural people that were on the lawn leading into his inauguration on the mall. He lied about stupid stuff, but that has real life consequences in terms of loan valuation. He said he lives in a 30,000 square foot apartment, double apartment in Trump Tower, about 3 blocks from me. It's not 30,000 square feet. It's 11,000, which, by the way, is gigantic, but it's 11,000. What? I mean, it's not like, he lives, no, it's only 1,000 square feet studio. No, it was 11,000 square feet anyway. But what is the difference? The difference is not just his ego, which is also part of it. The difference is $200 million. The difference between a 30,000 square foot apartment in Manhattan on Central Park and Fifth Avenue and an 11,000 square foot is $200 million. He does this time and time again. How he values the brand of Trump, which is like an ethereal amount of money based on how he feels when he wakes up in the morning, where he inflates his finances. She also pointed out in this filing, which I thought is going to get Trump dead to rights, which is they have 7,000 pages of documents that Trump is involved with, signature, emails, text messages. Do you know how many in the last 18 months? Do you know how many documents the Trump organization and Trump have turned over to the New York Attorney General total? 3. That's not a typo. Trump has turned over in 18 months and only in the last week 3 documents. She has 7,000 that other parties have with his name on it that he participated in. So they're like, wait a minute. How do you only have 3 out of 7,000 pieces of paper that other people on the other side of the email, the other side of the text message, the other side of the loan application have with you? He's got a problem. And this judge is going to order that Donald J. Trump, Trump Jr., and there's one more that they want, sit for a deposition under oath based on the 160 pages. Did she need to file 160 pages and put out her entire case, basically? No, but it was a shot across the bow and into the gut of the Trump organization that says, you think I'm playing? Go read my report. The public thinks I'm not doing my job. Go read my report. The right wing thinks I don't have anything. Go read my report and the volume of information that I have. And by the way, the implicit part, which she never says out loud, the quiet part that she never says out loud is everything I have. The Manhattan District Attorney's Office, which is prosecuting the crimes related to all this, they have it too.
Now, this is the part of the podcast that you've all been waiting for. We go over to Tish James' motion to compel to a victory in the Supreme Court for the January 6th committee to get those documents from the Trump White House that have been at the National Archives that Trump did not want out there. But before we do that, I want to tell you about our partner, Athletic Greens. If you've been watching this podcast, you see I'm drinking Athletic Greens on this podcast. Every podcast, I drink Athletic Greens every day. Let me break down to you Athletic Greens in the most simple terms. Before I had Athletic Greens, I had a counter that was filled with gummies. Yes, Popok, I did gummies and pills and things like that to give myself the vitamins and energy that I thought I needed, but I felt lethargic. It wasn't working. I don't know what I'm doing. I'm just mixing and matching things that I don't know, what they're about. But AG1 simplified it. It's a simple powder where you take a scoop of the powder, you put it in the cup, you shake it up with water, you drink it, and you have the energy that you need for today. You have all the vitamins and minerals that you need in a day.
Can I compliment you for a minute in the middle of your AG1? Please. I've known you for a long time. I met you pre-AG1. I met you pre your running and your bicycle regime. I met you pre this very aerodynamic haircut that you have for today, for those that are watching today, and this very snazzy polo shirt that complements your eyes. You were not this fit when I met you, and I know that AG1 contributed to your fitness.
It absolutely did. One tasty scoop of AG1 contains 75 vitamins, minerals, and whole food sourced ingredients, including multivitamin, multimineral, probiotic, green superfood blend, and more in one convenient daily serving. The special blend of high-quality, bioavailable ingredients in a scoop of AG1 work together to fill the nutritional gaps in your diet, support energy and focus, aid with gut health and digestion, and support a healthy immune system, effectively replacing multiple products or pills with one healthy, delicious drink. And as the research changes, so does AG1. While most nutritional products that come to market never evolve, Athletic Greens continues to obsessively improve AG1 based on the latest research, producing 53 improvements over the last decade and counting. They invest in the most absorbable and natural source of each ingredient and go above and beyond in third-party testing to ensure their customers continue to receive the highest quality and best daily nutritional habits on the planet. It's lifestyle friendly. So whether you eat keto, paleo, vegan, dairy-free, or gluten-free and it's lifestyle friendly. Whether you eat keto, paleo, vegan, dairy-free, or gluten-free, and it contains less than 1 gram of sugar, no GMOs, no nasty chemicals or artificial anything, while keeping it lasting good. Join the movement of athletes, lifeleets, moms, dads, rookies, first-timers, and everyone in between, taking ownership of their daily health and focusing on the nutritional products they really need in the simplest manner possible. That's essential nutrition. To make it easy, Athletic Greens is going to give you an immune-supporting free 1-year supply of vitamin D and 5 free travel packs with your first purchase. If you visit now, athleticgreens.com/legalaf today. Again, simply visit Athletic Greens, athleticgreens.com/legal, AFLEGALAF, and take control of your health and give AG1 a try. Popok, let's talk about the archives. The National Archives has the Trump White House records relating to January 6th. We know that Biden waived executive privilege, the claim with executive privilege that Trump tried to assert with past presidents. This worked its way up to the Supreme Court. You know, the DC Circuit basically held it's not even an executive privilege issue. So the issue over past versus current president, while the DC Circuit said, we think that a past president doesn't have the right to assert executive privilege, the DC Circuit said these documents would not meet any test. These documents should be turned over forthwith to the January 6th committee. This was appealed all the way up to the Supreme Court. Donald Trump wanted an injunction. He said, stop it. I'm litigating this case. Do not turn these documents over now to the Jan6 committee. And the Supreme Court, in a 8-1 vote, only Clarence Thomas dissented. There was a statement by Justice Kavanaugh over the fact about narrowing it to this case and saying that he's not making a decision about whether past presidents do or don't have executive privilege claims. This is just about the facts before him. But on an 8-1, only one dissent, Clarence Thomas. These documents are going to the Jan6 committee, baby.
A terrible week for Trump and an amazing and great week for the Meidas Mighty and legal AFers. Trump loses the Supreme Court at the National Archives. 700 documents immediately go to the Jan6 committee. We're already hearing about what's in that amazing treasure trove of information. And this isn't the 700 pages like, you know, like when you and I are in civil cases and the other side gives me a data dump with like phone books, newspapers, you know, kids' report cards. This is the choicest of material that Trump has been fighting tooth and nail to stop from being disclosed. That's one. Two, we're going to talk about Fani Willis, the prosecutor in Fulton County in Atlanta, who is convening or asking to convene a special grand jury against Trump for election interference on his phone call to the Secretary of State there. And Tish James, we just talked about, New York Attorney General issues a 160-page report outlining Trump and Trump Organization fraud at the highest levels. Isn't this a great week for Meidas Mighty?
Great week for the Meidas Mighty. I think we should. So what's going to happen? These documents are going to go to Benny Thompson, the chair of the committee, Liz Cheney. Others on the Jan6 committee are going to get to see it. The documents are going to trickle in. As of last week, Benny Thompson said he hadn't gotten most of the documents, but they'll come. So he will get.
They got the order of seizure for the voting equipment, and I think you guys talked about it. Your brothers and you talked about it on your other pod. So buried in the 700 pages, besides Mark Meadows' 7-page or 10-page notes, call logs, speeches that Trump was going to give, apparently when he was going to take over the country illegally. One of them was the order that they had written up in fashion to seize. I mean, I just have a chill down my spine again, to seize voting machines as part of this bullshit ruse about, you know, basically what it would have been the takeover of the country by a despot. You know, it reminds me, Ben, I don't know if you remember, there was a movie in the 1960s called 7 Days in May, which starred Burt Lancaster as an out-of-control, megalomaniacal general who decided that the president was too soft on the then Soviet Union. And right before the president was going to sign a peace treaty, this general got together with other seditionist members of the military, and they were going to hatch a plot to to actually take out the sitting president and replace him with this general. And of course, fortunately, patriots interceded and made sure that didn't happen. Anybody wants to, I thought it was fiction. When I was a kid, those kind of movies I was like, holy shit, thank God we don't live in a society like that. We were this close to it with Jan6, and those 700 pages are going to lead us to that conclusion.
We talked about it. I mean, look, you talked about the that with kind of a military coup. One of the things Trump did was he got rid of a number of leaders, in the military. He put in this guy, Kash Patel, who was made chief of staff to the acting secretary of defense. He had this radical right extremist Patel actually calling the shots, not deploying the National Guard on time when there was an insurrection. And so that's actually what Trump was trying to do. But I guess one thing I want to drill down on too, that's just a bit on the periphery, but we should talk about it with our legal AFers though, is Clarence Thomas. So Clarence Thomas wanted an injunction, wanted none of these documents being turned over. In past Supreme Courts, Clarence Thomas never spoke. He never really asked any questions. It's a bit of an exaggeration.
He asked one question in 25 years.
And now this is Clarence Thomas's time to shine. For all intents,
he won't shut up. Now he won't shut up.
Yeah. And so what we learn also, one of the things that's been written about, the New Yorker did a great article, and the article was called, "Is Ginny Thomas a Threat to the Supreme Court?" Virginia Thomas, Clarence Thomas's wife, was one of the people who were cheerleading the insurrectionists and saying this is a beautiful day, and saying the insurrectionists were great people, and words to that effect on Twitter. She had a small lobbying firm called like Liberty Lobbying Group that nobody's ever heard of in the past. But increasingly, what the issues that this group is facilitating and what they're helping with are issues that are before the court in terms of the Second Amendment, in terms of abortion, healthcare rights. And not only is, it'd be one thing, if she's, she's just the wife or the husband of a Supreme Court justice, but she's very vocal. She's very out there. In fact, what this New Yorker article talked about is there's actually like a private group chat that goes on of Justice Clarence Thomas's law clerks, his prior law clerks,
former law clerks
who are out there now as practicing attorneys and have high-level positions. And she's in there basically encouraging them to engage in litigation that would go before the court. Ultimately, these issues would be taking away a woman's right to choose. These would be putting military-style weapons in schools. These would be issues that would probably take away your health care. But she's acting as in an official capacity, basically in the chat room, stoking this up on cases that are being heard before Justice Clarence Thomas. This is completely unethical. This is completely absurd that this is happening. But it shows you that elections have consequences. And it's why we need to make sure that Biden gets a second term. We need to make sure that we vote and we elect Democrats, because what Mitch McConnell did with our judiciary, the machinations, the scheming to have this radical right extremist Supreme Court with people like Clarence Thomas, engaging in this conduct by proxy through his wife on these listservs is absurd.
So let's just use this quickly for people might be saying, and I've seen it on our feeds, disqualify Justice Thomas. He should recuse himself. There's a judicial code of conduct that applies to federal judges. Supreme Court justices are federal judges, but there is no independent Supreme Court code of conduct or code of ethics, if you will, that relates to when a Supreme Court justice should or should not recuse himself. The difference between recusal and disqualification is the following. Recusal is something that the judge does themselves when they recognize that either a rule has been violated of the judicial canons or there's an appearance of impropriety that makes it improper for them to sit on the case. And that's usually, the judge has to do the recusal themselves. Sometimes you'll see 8 people of the Supreme Court hearing a case because the 9th member either maybe represented that party in a prior life, or maybe they're invested, they have investments in that particular company that's before them. Or maybe you'll see 7 people up there because 2 people recuse themselves. Disqualification is slightly a horse of a different color. You have to move to disqualify, and you have to cite a canon of judicial conduct that's been violated, and then the judge has to make the ultimate decision whether they're going to be disqualified or not, having not recused themselves. Just because a wife or a husband has outlandish and outrageous positions does not mean that that is visited upon the judge, and the judge has to automatically recuse themselves because their spouse is out doing things that people find unsavory. But here, Ginny Thomas and Clarence are getting closer to the line of appearance of impropriety because she is actually involved with organizations. She's on the board. She's on advisory committees. She's in listservs and chats with groups that are actively filing amicus briefs before the Supreme Court, for which Clarence is not recusing himself, or are going to be involved in the case or are funding the case in some way. Now, technically, there has not been a party that Ginny Thomas is a part of that has been a plaintiff or defendant in a case in front of the Supreme Court. So technically, he hasn't had to recuse himself. But we're really getting borderline here on the submission of amicus briefs. Now, this is not the story. Look, James Carville has been married to Mary Matlin, one of a left-winger and one a right-winger forever, including during the Clinton campaign. But this is different. She is actively involved, and this is what your point is, in lobbying on behalf, indirectly or directly, on behalf of matters that are in the Supreme Court's docket or going to be. And, but everyone's like, well, impeach him. It's not going to lead to the impeachment of Clarence Thomas. Let's just manage expectations. But he should be recusing himself if he finds that there is an appearance of impropriety because amicus briefs are being submitted by organizations funded and supported and for which he's on the board of directors.
So it's just bizarre, Popok. I mean, to have this situation happening in the highest court of our land, but it's why the Supreme Court's popularity and approval rating is the lowest it's ever been, and it will get lower when the Dobbs versus Mississippi ruling comes out. I'm telling you, there will be protests across the country. And finally, Popok, turning to an update out of the Fulton County District Attorney Fani Willis out in Georgia is requesting a special grand jury to aid in her investigation of former President Donald Trump and his efforts to overturn Georgia's 2020 election results by a letter sent to the Honorable Christopher S. Brasher, the Chief Judge of the Fulton County Superior Court. The District Attorney Fani Willis requested by letter that this special grand jury be impaneled under the court's supervision. One of the reasons she requested a special grand jury is because in her requests to speak with people in the Trump administration and others, guess what? They don't want to cooperate. So by impaneling a special grand jury under court supervision, that would give her subpoena power to start requesting with court enforcement mechanisms that individuals discuss. Of course, this relates to Trump reaching out to Brad Raffensperger saying, find me 11,780 votes, and other intimidation tactics by Lindsey Graham and others. And this relates back to what we talked about at the beginning of the show, because Georgia is one of those states where the GQP extremists were having radical Republican legislatures prepare their own slate of electors that they were going to submit. And what they were trying to do was extort, coerce, threaten Raffensperger and the governor to not certify the election results so the fake electors could then be submitted and that Georgia could flip to Donald Trump, despite that's not what the vote count was. Donald Trump responded to this inquiry by repeating the big lie over and over again. What can be expected of the biggest liar in the history of mankind? But, it's why we need accountability, because Trump's out there still talking all these lies and still talking this shit. And we need to hold this ridiculous monster accountable.
I like Fani Willis's prosecution a lot. As I said in the last podcast, She's the only prosecutor out there that has Trump dead to rights because he actually picked up the phone and made the phone call to Raffensperger. We got corrected again. It's with a P, not a B. Raffensperger, the Secretary of State. He made the phone call in search of the 11,780 votes, extorted them, threatened them with criminal prosecution if they didn't agree to his plot. She's the only one that's got his fingerprints directly on a prosecution. And what, just briefly, because this is why Legal AFers come here week after week for this inside knowledge, special grand jury is different than a regular grand jury. Regular grand jury in Georgia, for instance, meets every 2 months, and they do a lot of felony drug cases. And you just bring, the prosecutors just come in ad seriatim one at a time, and they bring in their cases. And then that grand jury disappears. And then another grand jury with new people is sitting in the box a month later, 2 months later. She's asked for one special grand jury of 16 to 23 people to sit and listen to her evidence in order to issue subpoenas and compel testimony in aid of her investigation, because no one is cooperating with her voluntarily. She said, I've reached the limits of what I can do without compulsory, compelled testimony. Now, here's the interesting thing, Ben, you may not have known, and I didn't either. Here's the question I have for you. Special grand jury in Georgia, can it indict or can't it indict in their role? Can they issue an indictment?
You tell me, Popok.
They can't. So the special grand jury is actually an investigatory body only. They can compel subpoenas of all these people, including Raffensperger, who has said he wants to be subpoenaed in order to give his testimony. At the end, when she gets all of her evidence together in a bundle, then she goes back to the regular grand jury, which meets every 2 months, and presents all of her evidence and testimony there to have an indictment issued. So we're going to watch this closely, but things are beyond heating up against Trump and the criminal prosecution. And maybe, even though it wasn't mentioned directly in the letter that was sent to the judge, Lindsey Graham's got a problem too about his attempt to influence and interfere with the election in Georgia, because we believe that based on reporting, that is part of her investigation as well.
Well, look at her letter, District Attorney Fannie Willis. This is what she says. These are very strong words. She received our office, Fulton County DA, has received information indicating a reasonable probability that the state of Georgia's administration of elections in 2020, including the state's election of the President of the United States, was subject to possible criminal disruption. Big words, strong words from a DA. Popok, as always, love spending these weekends with you. Want to definitely plug Midas Touch Legal AF's Wednesday edition. Michael Popok and Karen Friedman Agnifilo break down issues midweek in more detail and more depth, focusing on less issues than we cover on the weekend editions of Legal AF, but really drilling down on areas. And I thought
30 minutes,
a simple 30-minute session, but everybody check that out every Wednesday. I want to give a special thanks to all of our sponsors. I want to thank Masterworks. I want to thank Smith AI. I want to thank Athletic Greens. As always, support our sponsors. It helps us continue to do these shows. We appreciate everybody who's contributed to Legal AF. Everyone said, here's my little tuition in the chat. So if you're able to contribute to Legal AF, just click that $sign on the YouTube and you can contribute to Legal AF, whatever you want to contribute. We appreciate that. And even if you can't do it, spread the word. You could always help us no matter what by subscribing to this podcast, by leaving a 5-star review. The 5-star reviews help this podcast grow in the algorithms, and we appreciate you so much. I'm going now to see the Midas Mighty meetup out here in Los Angeles. We'll see you next time on Midas Touch Legal AF. Ben Meiselas, Michael Popok signing off and saying a special shout out to the Midas Mighty.